All right, hi gang. Welcome back. Attorney Steve Vondran here. Welcome to another exciting video. This time we are talking contracts. This is a video from what I call Contract College. This is off my website, vondranlegal.com. You can find it right there, okay? So let's talk about it. What is a non-disparagement clause? Now, when you settle a case, could be an intellectual property case, copyright infringement, could be a domain dispute, could be a breach of contract, anything that you guys are resolving and settling. You need to think about what the other party is going to do. Is the other party the type that's going to go post things on the internet, that's going to go give interviews or give bad reviews, this, that, and the other? The non-disparagement clause complements a confidentiality clause. It complements. So I like to have both, and typically you would want a confidentiality clause that says everything's going to be confidential, and usually what that covers is the terms of the settlement and anything leading up to the settlement, sometimes the documents exchanged. These things can be part of a confidentiality agreement that you cannot share with anybody. A lot of times in a confidentiality agreement, we will say you can only say the case has been settled to our satisfaction, and that's all you can say. That's a confidentiality clause, okay? The non-disparagement clause, it's a tad bit different. We have it here. I'm going to go over just a couple, what they look like. But this is where you want to, in addition to that confidentiality, you don't want someone to get an assumed name or an anonymous name on the internet and go around and start disparaging you, okay, and trying to bring you down after the case is closed. Here's some sample language you can use. Settling party agrees not to take any action that is intended for or would reasonably be expected to harm. I just use ABC software here. To harm ABC software or any of its parents, affiliates, subsidiaries, or any of their officers, directors, employees, agents, or representatives, or their reputations, or lead to unwanted or unfavorable publicity to any of the foregoing individuals or entities. So they don't want you saying anything that would harm them, their business, their uppers, their lowers, their parent companies, their subsidiary companies, everything else. Settling party further agrees not to make or cause to be made either directly or indirectly any disparaging remarks, comments, or statements, whether in person, in print, or online, so that's online or offline, concerning any of the foregoing individuals or entities. So it's kind of like a gag order if you think about it. For purposes of this provision, disparaging remarks, comments, or statements are those that impugn the character, the honesty, the integrity, the morality, or the business acumen, or the abilities in relation to any aspect of their operation of the business of the foregoing individuals or entities. So it's very broad what considers disparaging. So it kind of quiets the other party down from engaging in any types of activities. Finally, last paragraph, notwithstanding the foregoing, nothing in this paragraph will prohibit any party from making any statement or disclosure that's required under the federal securities law or other applicable laws, provided, however, that such party must provide written notice to the other party at least 5 business days prior to making any such statement or disclosures required under any such law that would. So if you have to make a disclosure, there's some legal requirement that you disclose, you got to let them know first. So that's just a real basic here. That's our website here. Got some good things going. I will consider this to be Contracts College, Attorney Steve Contract College, essential terms in a settlement agreement. Hope that's helpful. If you like it, don't forget to subscribe. Yes, you can share our video on your social media networks. Have a great Friday. Hope you're all doing well. Talk to you soon.